Welcome to Tales from the Training Room, Burkett's bite-sized podcast series from the Shaping Excellence team. In this episode, Sam Greenhalgh and Jonathan Shevlane discuss how restrictive covenants operate in respect of exiting employees and how employers can best protect their interests. Both Sam and Johnny are members of the Shaping Excellence team, our training department. Sam, as partner, leads the team, and Johnny is our dedicated employment law trainer. During this episode, they look at how best to balance the interests of a company whilst ensuring the individual is treated fairly when leaving. They begin by explaining why preparing for an employee exit is of great importance to an HR professional.
So Sam, why are we looking at this topic today?
Well, very often we get asked to deliver training to managers and senior leaders and HR professionals about onboarding employees. And one of the things that needs to be taken into account when an employee is being onboarded is ensuring there is sufficient protection for the business in the event that that relationship turns sour. Now, clearly, we all want to think that at the start of an employee joining the organisation or the business is going to be nothing but positive and wonderful and great. But ultimately, employees come and go. And hopefully the business will stay intact. And it's important to protect business interests at that point.
But the real reason we're looking at it today is because employee turnover rates have been at a high since the pandemic, actually at historic high levels. And there was the Great Resignation. There was a lot of press coverage about the idea that people were reassessing their lives during the pandemic, and there was a great reduction in loyalty towards organisations during that period. And that's kind of presents a bit of a turbulent picture for employers and gives us even more reason to perhaps think about the end of an employment relationship, even when we're entering the contract at the very beginning of that relationship. So what would you expect an employer to be saying within a contract, and how would you expect an employer to want to try to protect their confidential information?
Well, if we take a bit of a step back and look at what the law provides in every employment relationship, there is an implied right of confidentiality, or implied duty of confidentiality between an employee and an employer. But actually, when you look at that common law right, it's very, very narrow based on, the highest of trade secrets that organisation has. And generally speaking, organisations would consider a much wider category of information and data and statistics and relationships to be considered confidential information. So in the employment contract, there's the opportunity to broaden that implied obligation to make it an express term that there's going to be information that will be required to be kept confidential forever after the employment ends, and of course during the employment as well. So things like customer lists, sales records, relationship contact details, vision, mission and strategy for the organisation moving forward, growth plans and projects, all of which would unlikely be covered by the implied term of confidentiality, and would be needing to be specified in an express term of confidentiality in an employment contract.
So what do you do from an employer perspective beyond making very clear in your contract that these are the things which are confidential, these are the aspects of your role which are confidential? What do you do if somebody is going to try to pass that information on at the end of a contractual relationship?
Well, there's the options that are available in terms of suing the ex-employee at that point for doing that, because you've suffered a loss as a result of what they've done and they've breached that express term of their employment contract. The problem with that, though, practically speaking, is that employees don't really have a lot of money. They might have a house, they might have a car, they might have some savings, but the possibility of recovering what could be tens of thousands, if not hundreds of thousands, or millions of pounds worth of loss that you say that you've got could be impossible to obtain. Equally, evidence is a big problem. So policing the fact that there has been a breach of confidentiality is very difficult. And saying that it's because of that employee's actions that your competitor has found out about your mission, vision and values, or your strategy, or whatever it might be, could be very difficult to prove. Yeah. So really, there is alternative methods used quite often to try and safeguard that confidential information.
Okay. And one other method that employers use, and I touched upon it earlier, are what's called post-termination restrictions. So while the provisions in relation to confidential information may be a little bit difficult to police from an employer's perspective, it might be a bit easier to police things like the classic non-compete or non-solicitation clauses which you have within a contract of employment. Do you want to just mention what I mean when I say non-compete?
Yeah, so we get asked this quite a lot, and we spend quite a lot of time talking about this and dissecting this within the training room. And there's various different types of things that an employer can do to restrict an ex-employee's behaviour post-employment. So they can prevent them from going to work for a competitor. They can prevent them from soliciting their clients and trying to obtain the client's work. They can prevent them from poaching staff who are key and important to that employer. They can prevent them from having dealings with clients or customers, or working with suppliers, perhaps, because that would give an unfair advantage to the supplier. So there's a number of steps in which an employer can take to try and restrict the behaviour of an employee post-employment. Now, many people will consider that they are just unenforceable. You can't enforce that kind of restriction on somebody who needs to go out and earn a living and will want to do something that they've always done. So if you train for many, many years to be an accountant, you want to be an accountant in the town that you live in, and you want to go to a different firm, to have a restriction where you can't do that could be quite onerous on you. Usually those restrictions are only for a certain period of time. Generally speaking, the shorter period of time, the better. But at all times, the employer who's trying to enforce those restrictions has got to demonstrate that there is, first of all, a legitimate interest to protect, and that the restriction is reasonable in all of the circumstances. And so it comes down to the evidence and the factual situation as to whether those tests would be met. And generally, it's quite a high burden to prove for the employer.
So Sam, you've got your post-termination restrictions in the contract of employment, and you have an employee, let's say 3 years down the line, who's decided to move on and move to a competitor organisation, and you're very worried that that individual will take confidential information with them, which will be detrimental to your company when they leave. You're also worried that that person might steal some of your clients. They might even try and poach some other members of your team. You've got those post-termination restrictions in the contract. What do you do next as an employer in that situation?
So I think when that situation arises, whether it's because you're about to dismiss the employee or because you've just received the resignation, it's important to take stock and look at the various options that you have. One of the things that's important to do is perhaps take some legal advice about whether those restrictions are actually enforceable at that point, because of course they could be X number of years old, the role could have changed, they may be worthless. And also to think about the appetite for enforcing them. But there may be other mechanisms within the employment contract that you can use to better protect the business and that confidential information, and that is arguably cheaper in the long run. So you've touched on garden leave. Garden leave is a standard clause that's in many contracts. And to put someone on garden leave means that they will serve their notice period or part of their notice period in the garden. So they're going to tend to their roses. Now, most people don't actually spend all the time tending to the roses.
They don't have to stay in the garden.
No, and they don't have to stay in the garden. So, but what it means is that they are not required and not expected to come into the workplace to perform their role. But crucially, they remain an employee of that organisation and they will continue to receive their salary during and benefits during that notice period.
Okay, that sounds quite nice from the employee's perspective. They get paid for doing nothing.
It does. And from the employer's point of view, you will of course already have had that payroll cost that you've budgeted for. What you are not getting is bang for your buck. You are not getting that work from that employee. But what you're getting instead is control. You can hold that employee out at arm's length from the organisation. They don't have any contact with clients and customers and employees, and you can control them to such an extent for the length of that notice period. And that can often be more valuable to you because during that intervening time, you sort out your team to cement those relationships that employee had with those key customers or key relationships that are so crucial to your organisation.
So it's almost like a paid non-compete for that period of time. It's therefore feels more fair to the individual because they're still able to earn a living during that period of time. But they're not being prevented from earning any money at all during that first, whatever it is, 3 months, 6 months when they're on garden leave. So that's obviously something which courts consider to be much fairer. And in your experience, has a garden leave clause ever been contested?
I always strongly, when I've got my legal advice hat on rather than my training hat on, I would always advise employer clients to utilise or consider utilising garden leave rather than paying in lieu of notice clause, which brings the employment to an end on that date and allows the employee to go off and do whatever they want. And if they think that those restrictions are unenforceable, they could go and work for your competitor, they could start stealing your clients, and then all you've got in terms of your protection is the ability to write and send letters and bring proceedings and pursue them for losses that you've sustained, which has all of its own issues in itself.
So generally, another point which I've picked up from what you've said is that enforcing post-termination restrictions can be very tricky. Yeah. Have you ever had any success stories that you could mention about enforcing post-termination restrictions?
Yeah, very few claims of post-termination, of breach of post-termination restrictions actually end up in issued proceedings, and even fewer of those end up going to a hearing, and even fewer of those end up going to be deemed to be enforceable. And generally what happens is that the ex-employer's lawyer will send a letter to the ex-employee and say, you have breached your restrictions in your employment contract, the employer is going to enforce them, and essentially it's a bit of a scaremongering letter. It's setting out the claims that the employer would have and the evidence that the employer would have to prove those claims, and the employee would then be required to get their own lawyer at their cost, and there'd be usually an argument between the lawyers about whether they are enforceable or not, and then often a pragmatic solution can be arrived at by the employee agreeing to give undertakings or to pay some form of compensation towards the employer, or cease doing what they had been doing, or to return clients to the ex-employer. So there's all sorts of ways in which the dispute can be settled, and usually the settlement of a dispute of that nature is beneficial for both parties than going to litigation, and going to a hearing. but it very much depends on the facts and circumstances and the strength of each party's position.
So evidence is absolutely vital, and gathering that evidence very quickly is really important in these cases.
Evidence is vital, and it's very hard to obtain, because if you imagine you're the business that thinks that you've just lost a whole load of clients because Natasha has gone and got another job elsewhere with a competitor, and all those clients have said they're going to the competitor, well, they may all be going to that competitor, but how do you know, employer, that is because of Natasha?
So we need to be thinking about the end of the employment relationship when we are drafting the employment contracts.
Yeah, at the beginning.
At the beginning. So thinking about worst case scenario at the beginning, it's kind of what lawyers do.
Puts you in the best negotiating position to protect your business interests, and diarising to review that at the point of promotions, at the point of salary changes, or whatever may be happening, or at least as a minimum every 2 years, employment contracts should be reviewed, even if they're just reviewed from the point of view of, yep, we're still happy with those, they've been reviewed, because things change, job roles change. The minute the employment contract's signed, it can get out of date quite quickly because of the pace in which some employment journeys can go on.
Brilliant.
That was Sam Greenhalgh and Jonny Shevlane discussing post-termination restrictions. If you found this episode of Tales from the Training Room useful, our Shaping Excellence team has a whole host of employment training courses available. Our training is practical, insightful, and always provided by the best legal professionals. Head to our Shaping Excellence training page at burkitts.co.uk to find out more. This podcast has been produced by Burkitts. The content of this podcast is for general information only. It is not and should not be taken as legal advice. If you require any further information in relation to this podcast, please contact us in the first instance via our website, burkitts.co.uk.